Hello and welcome to Inventor's Quick Tips. In this episode, we'll be discussing the final office action, what it means, and what are your options if you get one of these. Here we see some typical language you might see in a final office action, and these are pretty common. Many of the issued patents out there at one point or another were in a state of final office action. If you've received one, you may see some language in your notice similar to this. And as you can see, this text that's highlighted right here, it looks so intimidating. What does it mean? Well, basically it means at this point, you've had your chance to have your patent application examined, and we're at a stage where you can make some minor changes that might be able to get your patent application into the condition to be allowed. Or if it takes more than a minor change to do that, then other options will need to be used to get past this, and we'll talk about that next. First, let's refresh ourselves on the timeline of events when you file a patent application. Events on the bottom half of the screen are initiated by the inventor, and those on the top half come from the patent office. So to kick things off, the inventor files a patent application. Next, anywhere from typically 8 to 20 months, you will get a response from the patent office in the form of a non-final office action. Next, the inventor provides a response, possibly with claim changes, trying to get past the rejections and get a notice of allowance. In the non-final office action, there's a little bit more leeway and flexibility when responding. Typically, your response will be entered. Entered means being accepted into the record. If your claims after the non-final response are not in condition for allowance, then within some months you'll receive the final office action. So I show you these steps just to remind you where you are in the process when you usually receive a final office action. So now, what does it mean to have your application in the state of final rejection, and what are the options for the next steps? Let's talk about that. Here are some facts about final office actions. Typically, your second office action is a final office action, and the first office action is considered as non-final, as we showed in the timeline. You can respond to a final office action with claim amendments or arguments, but the types of changes you are allowed may be limited in scope. So if you file an amendment and there's considered to be too much changes in it, then it will not be entered, and then you will receive what's called an advisory action. In response to that, you can then file what's called a request for continued examination with an additional fee, and then your amendment will be entered. Entered basically is their terminology for meaning accepted into the record for consideration. Additionally, the Patent Office in recent years has something called an after-final program, which allows additional changes to be made if not too major. The bottom line is, it's only final until you give the Patent Office a little more money. So never give up on your invention just because you receive a final office action. Okay, this is not, Shark Tank or The Apprentice where you get a final rejection and then you're not allowed to pursue it anymore. So just remember that. And you may be wondering, what does it mean to have too many major changes or just a little bit of changes? Well, the criteria for having too many changes all depends on if additional searching is required by the examiner. So if you just make minor changes that sort of make things more restrictive, and the patent examiner feels that he or she doesn't have to make extra searching to search on your new claims, then it will likely be entered. But if you've added new things that weren't previously in the claims, and it would require the patent examiner to do a lot more searching to see if those claims are allowable, then at the stage of final office action, they are likely not to enter that amendment. And that means that you'd either have to pay an additional fee to do the RCE, request for continued examination, or some other options are available that we will talk about next. What are the next steps you can do after final? Again, just to reiterate, you still have a chance after a final office action, but it may require an additional fee depending on the circumstances. Here are some of the choices you can do. You can file an amendment with minor adjustments or arguments to try to get your application into allowance. You can file a request for continued examination, which allows you to make more significant changes to the claims. And additionally, you can do an appeal. Appeal basically gets it out of the examiner and in front of other people. There's different levels of appeal, including within the patent office or also within the court system. We're not going to really get into appeal here, but just be aware that there is an appeal process beyond just dealing with the examiner if you feel you've reached an impasse with your examiner. Lastly, you can abandon your application, decide just not to pursue it anymore. This decision could typically be based on prior art cited, so if the examiner in searching found some very strong prior art that's very similar to what you are doing and you feel you can't proceed with it, then abandonment may be an option. Or if your business model has changed or based on business considerations where you feel it's no longer worth pursuing, that's a decision sort of outside the scope of the patent application itself, but something to consider. So the takeaway here is when you get a final office action, don't panic. Take a look, assess your options, and try to do what's best for your situation. Thanks again for listening, and we hope to see you again on another episode of Inventor's Quick Tips.